Thank you for joining us. At this time, I'd like to ask the board members to introduce themselves.
Starting here.
Starting from right.
Good afternoon, Pat Smith, mayoral appointee.
Hello, Shireen Crawford, mayoral appointee.
Good evening, John Darsh. I use he, him pronouns, and I'm the executive director of CCRB.
Esmeralda Simmons, public advocate, appointee from Brooklyn, New York.
Good afternoon. My name is Joseph Puma. I go by he. I'm the city council designee to the board from Manhattan.
Hi, my name is Herman Merritt, City Council designate from Brooklyn.
John Siegel, mayoral appointee.
We have folks joining us online, Dr.
Yes. Could you please introduce yourself?
Hi, I'm Frank Dwyer. I'm a police commissioner designee.
Unmute.
Mute.
And Northern, mayoral appointee. And Joe Fox, police commissioner designate.
Ms. Northern and Mr. Dwyer, if you could reintroduce yourselves because we weren't playing you in the room.
June Northern, mayoral appointee.
Frank Dwyer, I'm a police commissioner designee.
Nobody else.
That's
Thank you
got
all.
me right, John? Joe Fox?
yes, we got you,
Yes.
Mr. Fox.
Thank you.
Thank you.
The next on the agenda is the adoption of the minute. Since we do not have the quorum, we will push the approval of the May minutes to next month. As we begin today's meeting, I want to acknowledge that June is the Pride Month, a time to recognize and support the LGBTQ+ communities who continues to advocate for the justice and equality, including their interaction with the law enforcement. May 25th marked the 5 years since the killing of George Floyd and the widespread protests that followed here in New York City and across the country. These demonstrations amplified the national conversation about the police accountability and underscored the importance of organizations like this board as New Yorkers continue to exercise their right to protest. It is essential that the CCRB has both the resources and the authority necessary to thoroughly investigate allegations of police misconduct, particularly those that arise from protest. This includes funding for additional staff, direct access to body-worn camera, footage exemption from this sealing status, and finally, disciplinary authority. Due to the budget constraint, the agency has closed 2,345 cases to date, including 611 closed in 2025 alone. These are cases in which the alleged misconduct falls squarely under the CCRB jurisdiction. However, we do not currently have the staff or the budget to investigate the allegation. As we reach the end of the budget session, I would like to call on the City Council and the administration to provide the CCRB with enough funding to both resume these investigations and improve the system of police oversight in our city. Now I will ask the Executive Director, Jonathan Darsh, to give us an agency update. John.
Thank you, Dr. Khalid. June is Pride Month, so I'd like to begin by wishing everyone a happy Pride. The CCRB Outreach Unit will be at Pride events in all 5 boroughs, so keep an eye out for our team at your local Pride, parade, or event. Last year, elected officials and members of the public again brought up the issue of including civilian criminal histories in CCRB closing reports. As a way of making sure that the agency continues to collect information needed for its investigations, while not potentially inserting bias into our closing reports, I instructed staff to make the following changes to how we draft closing reports. The section currently titled Mediation, Civil and Criminal Histories will be retitled Mediation and Civil Histories. The information about civilians' criminal histories formerly included in the above referenced section will continue to be included in an investigative action. An investigative action is how the CCRB keeps track of the work we do on an investigation in our computerized case tracking system. If civilians' criminal histories are directly relevant to the investigation, they will be referenced in the body of the closing report. Our office is open for walk-in complainants, but it is also possible to file complaints online at nyc.gov/CCRB complaint. That is nyc.gov/CCRB COMPLAINT. By telephone at 800-341-2272, by calling 311, or tagging the agency on Twitter, Facebook, and Instagram. For those wishing to speak during the public comment section of today's meeting, we ask that you keep your questions and comments to 4 minutes. If anyone wishes to file a complaint here tonight, we have 2 investigators on hand ready to take any new complaints. The investigators on call this afternoon are Rob Ryan and Emma Steidehar. We also have Ruth Villafane from the Civilian Assistance Unit to help out. I'm here for any questions, Dr. Khalid.
Any board member has any question?
If you want to introduce himself.
Yes. So,
Frank has a hand up.
AU, can you introduce yourself, please?
Yes, I'm A.U. Hogan. I'm a board member from the City Council.
Thank you. Thank you. You have a question? Yeah, Dwyer, you have a question, Frank?
I have a comment. The decision to remove civilian criminal records, I think, should also be met. The goal of an investigation is, as I think we would all agree, is to do an objective evaluation of the facts of a particular case. So at the moment, at the end, it would say Mr. Jones, who made the complaint, had no prior criminal record in New York City, or he had a disorderly conduct conviction 7 years ago. And we are now going to remove that, as I understand it. And we're going to have it in a separate file that's not part of the closing report that a board member would typically read. If a board member wanted to do some sort of computer search, they might find it, but it's not in the closing report. At the same time, the way the closing reports are written at the moment, and the closing report, for those who are not familiar with closing reports, are the documents that investigators prepare as summaries of the case with recommendations on each allegation. Well, at the moment, it has at the end, and Police Officer Jones had 3 prior complaints, one for this, one for that, one was substantiated, 2 weren't, etc. Okay. I believe, as happens in legal cases, these things are considered in legal cases when a penalty is being decided, but not the merits of the particular case. So what I want to recommend and open for discussion and perhaps vote on in a subsequent meeting, if a vote is required or there may be just general consent, is that the way what we're doing now with the civilian criminal record, we do with the allegations that prior the police officers had. Remove them from the closing report, let the facts of the case be evaluated in and of themselves, and then if there is a substantiation, one can look and see the pattern or non-pattern or relationship of other cases.
Can I respond?
Yeah,
to that,
go
Dr.?
ahead. Go ahead, John.
So, Mr. Dwyer, that's a very interesting point, and I had not considered it, so I will take it under advisement and report back to the board on it.
Thank you, Mr. Dosh.
Yeah, certainly we'll be looking at it, Frank, and see what we come up as a board. Thank you.
Mr. Chair, following up on what Frank said, we've just made a decision to withhold information from the members of this board who must decide whether a case is substantiated or not, with no consultation with this board. And I think this should be subject to some further discussion before it's implemented.
So I just want to clarify, no information is being taken away from the board. It will be in an investigative action that you will have full access to, and we'll make it very clear so that you can find it when you are reviewing a case.
Okay, I appreciate that.
Anybody else has any question, any board member? If none, then we'll go to a presentation from the deputy chief. I'm sorry. Did he say something?
No,
Oh,
it was just
okay.
a beep.
We go to a presentation from the Deputy Chief of Investigation, Assistant General Counsel, Suzanne O'Hare. Suzanne?
So before Suzanne gets started, I just want to say we've asked her to give this presentation in lieu of the normal outreach presentation, because I think it's important that the board, but also members of the public, understand what is involved in the CCRB investigation. And I want to thank Suzanne for putting this together so that we can all learn from it.
My pleasure. Good afternoon to everyone here today. Today, I'm going to make a presentation on the life of a case, or what we like to refer to as CCRB 101. A fine start already. All right, well, let's begin with our jurisdiction. CCRB has jurisdiction over what we traditionally refer to as FADO. That would be force, abuse of authority, discourtesy, and offensive language. And then there are two further categories. Discourtesy is generally referred to as use of profanity or some kinds of curse words. Offensive language is very specific use of words that indicate someone's ethnicity, their race, their age, their religion, and they can go hand in hand, but offensive language is always discourteous, but a discourtesy may not always be offensive language. Additionally, there are truthful statements. We have jurisdiction over the truthfulness of officer statements, and also in March 2021, the City Council resolved to enact the racial profiling and bias-based policing unit here at the CCRB. We have a 15-member board, although at the moment I believe we have 13 members available to us. 5 seats are appointed by the mayor. 5 seats are appointed by the City Council. 1 seat is appointed by the public advocate, and 3 by the police commissioner. And separately, the board chair is appointed by the mayor and the speaker of the New York City Council. As we know, our current chair, Dr. Khalid, is the acting chair, so he has been unilaterally appointed by our mayor to be our acting chair. Oh, come. The board is responsible, as you all are aware, for making disciplinary recommendations and recommendations only to the police commissioner. As we all know, our police commissioner is the final arbiter of discipline. There are certain laws that govern our work here at CCRB. Our foundational documents are in the New York City Charter in Chapter 18. Basically, they state what it is that we can do here at CCRB and how we can do it. We are additionally governed by FOIL, that is the Freedom of Information laws, and that designates what it is that we're allowed to disclose. For example, we generally do not ever disclose anything of an open investigation, but we are further constrained by those freedom of information laws. Also, we are learned from Civil Service Law Section 50A, which for a long time was a very important law that prevented us from revealing any information about the police officers and their prior disciplinary history. And that was repealed by Governor Cuomo and so is no longer applicable. We are governed by the Civil Service Law, Section 17. That tells us the statute of limitations and disciplinary processes. For example, for police officers and actually many other public servants, such as teachers or members of sanitation, the statute of limitations is 18 months from the date of the incident. And it also lays out the disciplinary processes. And there is a crime exception found in Section 75, Subdivision 4. It's a crime exception to the statute of limitations if the misconduct alleged makes out the elements of a penal law, a crime that is enumerated in the penal law, then the statute of limitations would not apply. And finally, we are governed by the Memorandum of Understanding that is between CCRB and the NYPD, and that is what governs our administrative prosecution unit. Intake, our intake unit receives complaints in a variety of ways. You can call us directly. You can go to our website and file a complaint online. Some civilians call 311 and they will determine that who they really want to talk to is us at CCRB, and so they will redirect that call. Sometimes civilians call the Internal Affairs Bureau directly, and Internal Affairs recognizes that whatever the complaint is more appropriately referred to us, and we will get a referral from them. Additionally, every day that the CCRB is open, we are open for in-person walk-in complaints. You can come in without an appointment, and we will be able to provide you with an investigator to whom you can make your complaint, and we will begin the process. And then sometimes we get referrals from other city agencies. Sometimes people go to their local assembly persons or perhaps the public advocate's office, and we get it from them. So for case screening, when we get a complaint, our intake staff talks to the complainant, tries to make a little determination as to whether there is, in fact, a FADO present that would give CCRB jurisdiction. Or they may determine that the case does not appropriately belong here. And so it could be referred out to the chief of department back at NYPD. It might be referred to IAB. Or other agencies. Sometimes a civilian will call us and say, you know, I had an unfortunate incident with a police officer and I want to file a complaint. And intake may say, well, where did this occur? And they might say, well, it happened on the Staten Island ferry. Well, that might not be NYPD. That could be Port Authority Police. Or if it happened on the PATH train, that is likely not under NYPD jurisdiction, and so we would refer those cases out. However, if intake does determine that there has been a FADO, then they will submit that case to our investigations unit. The case will be assigned to an investigator. It will be reviewed by their manager and assigned to an investigator, and they will begin the investigation. It always begins by interviewing the complainant, trying to ascertain what facts are important and relevant, and to gather as much information as they can about what happened, where it happened, who might have been there, other witnesses. And we can sometimes employ the use of our field team. That's a separate unit that is comprised of level 3 investigators who can go out into the community and find witnesses who might have been privy to information about that particular incident. They will also try to obtain any video evidence. They will order body-worn camera video. Sometimes we will use the field team to go out and determine if there's any surveillance cameras about from local businesses, or sometimes Viper cameras, which are NYPD controlled. The investigator will also order any necessary NYPD documents. There is a whole host of different documents depending on any given situation, and they will begin that process of ordering that. Once they have a basic understanding of the incident, they will set up interviews with the officers who were present, both subject officers and witness officers. And they will also consult with an agency attorney. The general counsel's office has 4 attorneys working within it who have legal consults with all of the investigators. We have very specific consults for mandatory meetings where we need to do a little bit more of an in-depth dive, but we are also available all along the way if they need a little assistance. Here is a list of some of examples of different documents that might be requested from NYPD. Memo books where officers are required to log any activity and particularly law enforcement action that they take during the course of a tour. UF 250s used to be called stop, question, and frisk forms. Body-worn camera, command logs, which are kept at the precinct, which would list arrests made, any strip searches that are done at the precinct. Tactical plans, where, for example, there is a mandatory kind of checkpoint that the precinct does. For example, driving while intoxicated, they will stop a certain number of cars. And the tactical plans lay out exactly what is expected of the officers in that unit. Officer photos are gathered, sometimes to identify different officers. We get motor vehicle pool information, find out who was assigned what sector car and at what times. There is AVL information, automated vehicle locator devices that are that every sector car and RMP are equipped with, and that can tell us where any individual NYPD car is at any given time on any given date, and also the speed at which they're driving their car. Internal affairs documents, aided reports, which are reports of civilians who have been injured, or medical treatment of prisoners where the suspect has been arrested and needs medical treatment. Threat, resistance, or injury reports, every officer is required to fill those out wherever there is any kind of physical altercation. And then, of course, 911 and Sprint reports are available as well. There we go. So once the investigation has gathered all of this information and interviewed all of the people that they need to talk to, then the investigator drafts the closing report. And they do so in consultation with their manager or their supervising investigator. The manager reviews drafts, makes changes, makes edits. And then once the manager signs off on that closing report, it's sent to an assistant general counsel for a review of its legal sufficiency. And as soon as that review has been satisfied, then that case is ready to be sent to a board panel for your review and your vote. Board panels meet in panels of 3. There is always a diversity of board panels where there is always one mayoral appointee, one police department appointee, and one city council appointee. Now, the public advocate appointee and the chair get to sit on those panels in either a mayoral capacity or a city council capacity. And for each panel, as you know only too well, the board members review approximately 30 to 50 cases per panel. Those 3 members of the panels review and vote on those cases, and if for any reason they are unable to come to a majority vote, or it is a case that is a notable case that results in a death or an officer shooting, then those cases go to the full board and are heard by whatever members, a quorum of which we have reviewing the full board case. There we are. Good Lord. So we have 5 different types of dispositions. The first is substantiated, and of course, our burden of proof is always a preponderance of the evidence. That means it is more likely than not to have occurred the way the investigation has determined, 51%. And substantiated would be a vote where the investigation found by a preponderance that the misconduct actually occurred. The next type is unable to determine, and that is where the investigation was unable to determine, based upon the evidence that they collected, whether the misconduct occurred or did not. Unfounded means that they determined by a preponderance of the evidence that the alleged misconduct never occurred. Within guidelines, it's a determination that the officer did, in fact, engage in the conduct that is alleged by the civilian, but that conduct was justified, was appropriate given the situation. And finally, there's other possible misconduct noted. These are situations where the investigation does not investigate that allocation. They look at, they will determine from whatever evidence they're reviewing, most often video evidence, they will see something that they realize is very likely police misconduct, but is not within our jurisdiction. And so in those cases, we present that to the board to say, we believe that this is other possible misconduct, and we recommend that this be referred back to NYPD, and the board votes on whether that is an appropriate disposition. NYPD established a disciplinary matrix in January of 2021, and CCRB and NYPD signed a memorandum of understanding the following month, in which we agreed to follow the matrix exactly to the letter for one year. And this matrix includes presumptive penalties as well as aggravating and mitigating penalties. An example of aggravating and mitigating is the rank and length of tenure of the officer. If an officer was only on the force for 1 year and had no prior CCRB allegations, that might be a mitigating penalty, a mitigating factor to consider. Whereas if that officer were, for example, a lieutenant and had 15 years on the job, we might expect a better understanding of the patrol guide and the rules, and therefore we might consider that to be an aggravating factor. And the matrix also employs progressive discipline. That means that the officer's prior NYPD disciplinary history, as well as their CCRB history, will be a factor in any board recommendation. So to our administrative prosecution unit, any case where the board recommends charges and specifications will go to the APU. The police commissioner does have a carve-out for charges and specifications, and it is sometimes referred to colloquially as a P2. And that is where the police commissioner determines that the officer has had no prior CCRB allegations, and the police commissioner determines that NYPD will keep that case and make its own determinations. And then the other recommendations, which are generally command disciplines, we have command discipline A, which is the least serious the least penalty available, our command discipline B. Those are handled through the department advocate's office. We file charges through the department advocate's office. The APU fills out a charging document and presents it, and DAO notifies the officer, has them come in, and they are served with those charges, and that service stops the statute of limitations clock. And so then APU can proceed with its trials and trial preparations. And also it's important to note that we can, in APU, make plea offers, and we should also note that most cases are resolved with the penalty of a loss of vacation days. There are historical databases where civilians are allowed to look up the police officers. As I indicated before, the Section 50A that prevented that law has since been repealed. So there are a number of different databases where civilians can look up police officers. One of them is the CCRB database, and you can find that at www.nyc.gov/site/ccrb/policy/mos-records.page. Also, the New York Civil Liberties Union has a database, and that can be found at www.nyclu.org/en/campaigns/NYPD-misconduct-database. NYPD maintains its own database, and that is available to the public. And you can find that at nypdonline.org/link/2. And finally, the Legal Aid Society has a COP accountability project, and that also has a database which can be found at www.capstat.nyc/officers. And that concludes CCRB 101. I am happy to take the applause, but I'm also happy to take any questions that you have.
Going back to filing the complaints, I think the complainants can go to a police station as well, file there as well.
You are absolutely correct, Dr. Khalid. Any civilian who wishes to file a complaint can go to any police precinct, any station house. It does not have to be the precinct in which the misconduct is alleged to have occurred. And the police officers at the desk are required to assist you in filing that claim. They can also provide you, if you wish, they can provide you just with the form, and you can take that away and fill that out. So excellent point, Dr. Khalid.
Any board member has any question?
Could you just specify where sexual misconduct by police officers fall within the FADA?
Sure. That is considered an abuse of authority for certain sexual misconduct. Something of a very great magnitude, such as an allegation of a forcible rape, might come under the F of FADO for force, but in general, it is abuse of authority. It is where an officer, under color of his or her authority, exercises control over another person, and in this case, it would be sexual abuse. Mr. Smith?
Yes.
Outstanding presentation. I have been blessed over the last 2 years to learn from you. I can't stop being an editor, though.
Oh,
You mentioned that Governor Cuomo revoked the civil service.
I think I said repealed, but okay.
Okay. He did that by executive order, or he signed legislation passed by the legislature?
It was, in fact, to my understanding, it was in fact legislation. It went through a lot of conversation, and it was quite a contentious debate. But it's my understanding that through legislation, which he signed, it was repealed.
Yeah. Okay.
Thank you for bringing that up.
Yeah. Well, it's a sensitive time right now. I don't want to be on the bad side of it. Yeah.
So I just wanted to clarify one thing in that there are currently 4 vacancies. I think is where we do not have a permanent chair. And we're also missing the city council appointee from the Bronx, one of the police commissioner designees, and a mayoral appointee.
Thank you for that clarification. I'll update my presentation.
Anybody else has any question, board members?
Thank you so
Thank
much
you,
for
sir.
your attention.
Thank you very much. Thank you. Now we will go back to the public comment. And now the public comment portion of the meeting will begin with those joining us virtually and who would like to make a comment, followed by those who are joining us in person. So for those joining virtually, please use the raise your hand feature. Please keep your comment to 4 minutes. Yohara?
Thank
Would
you,
have
Chair.
someone?
Yes, first we'll be hearing from Eric Dim, followed by John Macari.
Good afternoon, everyone. Can you hear me?
Yes.
Yes.
Sure. I'd like to say hello to Jonathan Darsh and, of course, Joseph Fox. Happy Pride Month to everyone, if you do celebrate or not. Other than that, let's get down to tax brass and let's talk about civilian complaint business. I overheard in this discussion about criminal records being relevant to a civilian complaint case. Now, it's my argument that is polarizing, and it's my opinion based on anecdotal experience that all criminal records are applicable in a arrest case situation, especially for police officers that conduct and perform intrusive police work, and especially those that take part in specialized units. Now, what I'm curious, hopefully you can respond after this, Jonathan Darsh. When you talk about criminal records being relevant, are we talking about convictions or actual arrest? What's important to note is that when a specialized unit makes a potential apprehension or approaches a potential perpetrator, person of interest, or subject, those officers make their tactical plans based on the arrest record of a perpetrator and not the conviction rate. There's a complete dichotomy. Many perpetrators, especially in New York City, with a pro-criminal legislation, are arrested numerous times for resisting arrest and also assaulting police officers. And those cases never meet conviction. In some cases, there are robberies, alleged violent crimes that never meet actual conviction, and some are pled out to disorderly conduct or lower cases. And those police officers make their tactical plans based on the arrest record, not a conviction. A conviction rate would not be a correct mirror and a reflection of the actual approach those police officers need to make to keep the residents of New York City safe along themselves. Now, the second thing I like to discuss is bias-based policing. That's something that's been servicing myself and John McCarry, who will speak next. We are the co-host of New York's Finest Retired and Unfiltered podcast, where we talk about perspective of policing, politics, anything centric around public safety, especially in New York and the entire nation. And what we notice with this bias-based policing, that it's biased in itself and that it's lacking the ability to prove or disprove an actual case. Now, we hear of a particular case with 3 police officers being found guilty of the 113 precinct. Those 3 police officers happen to be white male police officers doing intrusive police work, very active in comparison to their other police officers in that particular precinct, making arrests of violent perpetrators in that particular precinct. Now, the only fault of those police officers is engaging in intrusive police work and being more active than other police officers. Now, based on evidence and anecdotal experience, it's pretty much impossible to prove or disprove unless someone says, I stopped this person because I'm black. Other than that, this is based on thoughts and complete emotion. I find it pretty impossible to prove or disprove an actual bias complaint. And the problem with the allegation alone of those type of complaints, especially with public record, is the allegation is just as damaging as finding a substantiation. Because with those allegations, it's a misrepresentation of character and the reputation of a police officer. And that police officer can be painted as a bigot, a racist, and a prejudice, not only in their careers, but in their entire life. And that's a major problem. I'd like to ask also, Jonathan Darsh, have we found any cases of bias-based policing for black or brown police officers towards potential white persons of interest or subjects? I want to thank everyone for their time. I appreciate it. We need to have more conversations just as this. Opposition meets opportunity. I'm Eric Dim, former lieutenant of the NYPD, coined as the most complaint cop. Thank you, everyone. Have a great day.
So with regard to the conviction histories, when a conviction history is relevant, it will be included in the closing report. Even when a conviction history is not relevant to an incident, it will be collected and kept in the case tracking system in an investigative action that will be easily accessible by the board members. With regard to the comments about racial profiling, the CCRB does not substantiate every allegation of racial profiling it receives. If you look at the statistics that we put out, there are many times where the CCRB investigates profiling and does not substantiate misconduct. For example, in one incident that happened early in the racial profiling bias-based policing unit's tenure, there was a civilian who felt that she was targeted because of her race. The civilian was Asian. We were able to determine that the police became involved in the situation because they were called by a sanitation worker who was engaged with this civilian and was concerned about the civilian's behavior. So the CCRB takes these allegations very seriously. We investigate them thoroughly, and we make our presentations to the board, and the board is the one that makes the determination about whether the CCRB believes racial profiling or bias-based policing occurred. We then present that work to the NYPD, and in all of the cases that I have seen so far where we have substantiated either profiling or bias-based policing, we will bring those complaints to the Administrative Prosecution Unit, which will bring them to a Deputy Commissioner of Trials, either the Deputy Commissioner of Trials herself or an Assistant Deputy Commissioner of Trials, who will then make a recommendation to the Police Commission. So this is not some kangaroo court designed to impugn the reputation of members of service. This is a very new area for the CCRB, and I understand why it is so sensitive for members of service. Accusations of this type are extremely sensitive in nature and can impact someone's reputation. So as we move forward and we interact with the police department on these issues, I'm sure there will be changes in how we conduct our investigations. But in the end, we are not here to wantonly attack police officers. We get complaints and we investigate complaints. And the staff makes recommendations to the board, and then the board gets to decide what to do with the staff recommendations. And while I do know that the CCRB has substantiated allegations of bias-based policing against Black and Latino members of service, I do not know the category of civilian that they were accused of bias against, whether it was people who were similarly situated to themselves, or if it was by religion or disability or gender expression. There are a wide variety of protected classes that the racial profiling unit investigates complaints of prejudice against. Yeah, if you want to go to Lieutenant McCary.
Go ahead, McCarty.
You guys hear me?
Yep. Yes.
All right. How's everybody doing? I'm John McCary. So, we've been working on something, and we're gonna lobby not only City Council but the State Assembly as well as the Governor's Office to kind of give a clean slate to members of the NYPD as it concerns CCRBs, whether they're substantiated, unfounded. With the repeal of 50A and the creation of a private website, 50a.org, the things that happen at work, whether warranted or not, the substantiations aren't, when they are substantiated or they're not, these are remaining public record on officers' records in retirement and even in death for eternity. Now, I don't know what could be done to rectify a private website, but we will be lobbying for legislation to have the public record portion of it closed. When officers retire, similar to a clean slate act, similar to what Chairman Dwyer was talking about as it was relating to the case closings. We have a clean slate act for criminals in New York City, and I think although officers can make mistakes at work too, it shouldn't carry them their entire lives. So, and we could speak about that at a later date, and I would hope to, and I would love to run that piece of legislation by the board and hopefully get you guys to agree and to sign off on it, as well as we could have an officer who has a complaint in his first year of service and winds up serving 30 years and never receives another complaint. That complaint will carry them their entire career. So it's just something I just wanted to comment on. But I really came to ask two questions about bias-based policing. Obviously, I share the same sentiments as Eric. I feel like we're labeling. This is very new, John, not only for the CCRB, but I think in general for society, we're basically labeling people bigots. And I think the data is very concerning that we're grabbing to say this. These are far-reaching accusations, and they're scary accusations. And it's something I brought up with the Internal Affairs Administration while I was still working with you as the CCRB liaison. I was very concerned at how you would prove the allegation. Like, how could you prove? So my two questions are this. One, I going back to the case that Eric Dim was talking about, the CCRB was using a chief data scientist to see that the amount of people of color were similar. The amount of people of color that were stopped by those officers were similar to similarly situated officers, and they were drawing that based upon census data. So my one question is are you still using this data scientist to prove bias-based allegations? And my other question is, does the CCRB self-initiate any bias-based policing allegations against members of the NYPD? Thank you guys for your time.
Go ahead.
Dr. Could you mind if I answer?
Yes, yeah, go ahead.
CCRB still employs Dr. Winter. She was credited by the New York City Police Department as an expert when she testified at that trial. And I think her work is very professional. And if you look at the work that the administrative prosecution has done as a whole, if you look at the work that the Racial Profiling and Bias-Based Policing Unit has done as a whole, and the work that Dr. Winter has done, she is not always substantiating or recommending substantiating misconduct in biased policing cases against police officers. And in fact, the substantiation rate is very similar for general investigations and racial profile. When the CCRB uses data in its analysis of a profiling complaint, the first thing to note is before we even request data, we review it to see if on its face we can eliminate the possibility of profiling. For example, in that situation that I referred to in my response to Lieutenant Dim's question, we did not need data to know that the members of service who responded to that sanitation worker's request for assistance were profiling the civilian because she was Asian. We were able to look at the evidence that we found from the communications between the sanitation worker and 911, and that was able for us to recommend to the board not to substantiate the allegations against the members of service involved in that complaint. Even when we use data is just one factor in 6 categories of data that we look at, 6 categories of information that we weigh, 6 factors when looking at whether or not there is circumstantial evidence of profiling. And I will confess to you all that I should know those 6 factors, and I wrote several emails about them yesterday. Now that I need to call them back at the top of my head, they are escaping me. So I would like to apologize to everyone. I should know that and don't know it. And if someone was going to text me from our staff with those 6 factors, so that I will come back to that. If I won't come back because I think someone's texted it to me just now. Thank you, Andre.
Magic.
Oh no, that was not that response I wanted. So, with regard to the Clean Slate for Police Act, I was lucky to have Assemblymember Berger reach out to our office, and I met with him and reviewed the legislation. I don't know that the board is familiar with it, so I cannot speak for the board. I know that I am sympathetic to the intent of the bill, but I have real concerns about the impact of the bill as it is currently written. Number one, it says it's going to seal claims of misconduct against police officers. And I think that is because it is a bill aimed at the state, and they don't want to limit themselves to New York City. But it is extremely concerning to me as the executive director of the New York City Civilian Complaint Review Board, because we do not have claims, we have complaints and we have allegations. And then when an allegation has been substantiated, there is a disciplinary case. So unless the bill goes further to explain and define what is meant by a claim, I think I would be reluctant to support the bill. The second issue is it uses the language sealed, which is problematic because it would mean that we could not explain to the civilians who brought the complaint, who are involved in the complaint, that we did not substantiate what happened in their complaint. And many times the CCRB determines that the conduct of the member of service who is complained about is within guidelines, that the police officer acted in a way that upset the civilian, but was not doing so in a way that was contrary to the law or NYPD procedure. But if you cannot explain that to the civilian and explain why that happens, instead of improving police community relations, you are making people feel that coming to the CCRB is of no merit. It does not help, and they feel the need to take matters into their own hands, perhaps. And so I think that one provision is very problematic. The other problem I saw with the bill is because it is so broad, it does not contemplate that sometimes CCRB complaints have allegations that result in substantiations against one member of service, and then all the other allegations against a member of service are not substantiated. So in those complaints where you have a substantiated allegation and non-substantiated allegations against the same member of service, are those sealed or are those not sealed? That is unclear from this proposed legislation. The other thing the legislation does not contemplate is there may be multiple members of service involved in a complaint. What happens when one member of service has a substantiated allegation and then the other members of service who are subjects in the investigation do not have substantiated allegations? Is that complaint sealed? Should we be able to tell the public what happened in the substantiated case? So that is, I just want to go back to on my answer because our very helpful general counsel sent me what the 6 factors are. They are the sequence of events in which the encounter occurred, any departures from customary practice of the department or the member of service or their unit, a violation of law that may have been committed by the member of service, falsity of explanation for the conduct of the police officer involved, the data that I described earlier, and then a history of prior similar misconduct. And all of those factors should be considered and weighed when determining whether or not there is circumstantial evidence about whether an officer engaged in profiling or bias-based policing.
Do you hear anybody next?
No, Chair, that concludes the virtual portion.
For those joining us in person are here interested in making a public comment, please line up behind the podium. Please keep your comments to 4 minutes. Mr. Michael Myers, welcome.
Thank you, Mr. Chairman. 4 minutes, I don't have the time to reply to that nonsense. I don't have the time.
We'll give you 1 minute.
I don't have the interest. Hap. You know, to abuse the public. That's what this is, an abuse of the public. You have a public comment. We're wasting our time here listening to a board meeting in public session. We have to hear from police officers with their complaints. Come on. They don't want to stick around and hear from us. Some of them come to the sessions. Please. I'm so angry I hear this nonsense. Anyway, going to the agenda. I want to say openly that I commend the staff of the CCRB for their courtesy. They always are very courteous to me, and I'm not always in a disposition to be courteous to. So I want to commend them. I don't know if they're here or not, but please express my commendation to them. However, I still cannot get up to this room. The people downstairs, those 2, I'm not going to even describe them, but especially that one person who I've already complained about. She has to call upstairs to see if I can come into a public meeting. What the hell is this? Is this a public meeting? Why does she have to call up to clear me to come upstairs and take 10 to 15 minutes while I'm waiting to come to a public meeting? This is ridiculous. Now I've already complained to her supervisors. Those wimpy souls. You were supposed to follow up. Apparently they're ignoring you too. Where's the police commissioner? What's her name again? Oh yeah, Tish. I see her on TV. I see her running her mouth on TV. But has she been invited to a CCRB meeting yet? How many years has it been? I've been coming to this board meeting so many years asking, let's have a conversation with the police commissioner in public. Let the police commissioner eyeball every member of this commission. And you eyeball the police commissioner. I keep asking, have we asked for a meeting, a public meeting with the police commissioner, including this last one? Tish, I see her on TV running her mouth all the time about her police and her policies, but don't make any sense. But if she's gonna not make sense, let her not make sense here, so we can respond to her with our growls, although we won't have time to respond to all that nonsense. So I don't understand why we still haven't gotten a public meeting with the police commissioner, any police commissioner. Acting chair. Why are you still acting chair? Public, and to this commission, for the chair to continue coming here month after month, year after year, acting in front of his name. People don't take you seriously. People cannot expect to take you seriously. Let's put it that way. I take you seriously. People are not expected to take you seriously. If the mayor doesn't have the time or the patience or the consideration to evaluate who he appoints to this board as the chair of the CCRB. And I get offended, but I know you don't get to take offense. I take exception on your behalf and on the people who are angry that this man doesn't have time to fully establish and appoint people to this commission. I don't understand what's the delay. Year after year after year after year, we still can't get a chair because he doesn't care. He doesn't care. He cares about what he cares about, and what he needs to do, he runs his mouth and he takes care of his own business, but not our business. And you would think that a former police officer or lieutenant, whatever he was, would understand that there shouldn't be things held over people's heads based on complaints about their misconduct. Whatever that foe is. Come on. 4 vacancies now. I heard 3, but 4 vacancies. Why? Do we have a quorum today, by the way? I couldn't tell. I was late getting upstairs. I couldn't get upstairs. I couldn't see who the voting members here. Do we have a quorum to accept the minutes and to do formal actions? Do we have a quorum?
We did not have a quorum.
Yeah. Somebody ought to tell the mayor we can't even have a damn quorum because we can't get members to come to public meetings. If they're too busy to come to meetings, get off the board, I say again and again and again and again. There are plenty of people who can fill those seats and who will come to meetings. It's just disgraceful. It's disgraceful. And why am I only one? Why isn't this board complaining right to your appointees and say, what the hell is going on? Why can't you make an appointment, Mr. Mayor? Miss Speaker, or whatever your name is? Everybody's running for office, but they don't have time to do their business once they're in office. It's disgusting. Finally, because I know my time is already over, the Executive Director's monthly report. It would be nice, Mr. Executive Director, if we could get this report at least 2 days in advance. 2 days in advance. I always go to the website to get the reports in advance of the meeting. I can't comment on this extensive report in less than 2 minutes. I can't even read it in less than 2 minutes. We need it at least 2 days before the public meeting so we can make comments on the report at the meeting, not the month after or the 2 months after the report. We need it timely reports. Timely reports. So, my point of information, my point of order, I can't make a point of order because I'm not a member, but my point of information is how come people who are not even here can ask questions and then get long-winded answers, taking up our time and get long-winded answers. I make a point of information, point of order. This should not be. If you can't come to meetings and speak your piece, I don't want to waste the public's time with these people who have personal agendas or police officer agendas with my time. And I'm waiting to hear from the people and to hear from you, the representative of the people. I don't want to hear this nonsense. Let them come to the meetings where they've got complaints with and have their lawyers complain. I don't want to hear that nonsense. I'm sick of this.
Thank you, Mr. Meyer, for your comments.
Mr. Chair, I do want to acknowledge that we should endeavor to get the executive director's report online earlier than we did this month. We were having some transition in our communications office, so that will be different next month.
We'll be working on it soon. I promise. I promise. We'll work. We're working on the board members as well for your information. So we'll Hopefully, we'll have the full board soon, hopefully. Next, is any old business to come before the board? None. Do we have any new business to come before the board? Seeing none, I'm going to move now. We break into executive session. The agenda for the. Somebody said
I
something?
said so moved.
Also, thank you. The agenda for executive session is the executive director will consider two full board cases discussing pending personal action, and general counsel will provide update regarding pending litigations. If there's a motion to adjourn the executive session, do I have a second? So moved.
Second. Second.
Thank you. The meeting is now adjourned and we'll go into the executive session. Thank you all for coming. Appreciate that.